Welcome to Oil and Gas with Energy Law Prof. Today we're going to talk about the implied covenant to protect against drainage. So as a reminder, these implied covenants are duties that aren't stated in the lease, but that the courts imply generally to assure that the lessor, the landowner, is going to get sufficient compensation from the lease, because the landowner's compensation depends on the oil and gas company's production, and generally the landowner is going to be more interested in rapid production than the oil and gas company, because the oil and gas company has to pay for everything it takes to provide that rapid production, whereas the landowner doesn't have to pay any of the costs of development, and so just wants as much production as quickly as possible. So we're going to talk about this with this Amico versus Alexander case, which in your 8th edition textbook is on page 369. This is a case from the Texas Supreme Court in 1981. This is a case where we have a company, Amico, the lessee, that has the leases in multiple places on the same field. And so this case, the court talks about it as a field-wide drainage case. Well, what's the reason for that? Basically, the concern here of the lessor, the Alexanders, is that Amico is not sufficiently interested in getting oil production from their lease, because according to the Alexanders, they believe that Amico thinks if we don't get oil from the Alexanders' lease, no problem, because that oil, as that oil rises, as more and more of the oil is extracted and the water underneath rises, we're eventually not going to get any more oil from the existing well on the Alexanders' land. But the Alexanders say that's not a problem for Amico, because they'll continue to receive oil from this other lease that they have on the same reservoir. And the Alexanders are particularly concerned about that, because on this lease, this other lease that will continue producing, as the court calls it, the up-dip lease, because it's the reservoir extends up toward that other lease, Amico is paying a smaller royalty. And so the Alexanders have the suspicion that maybe they don't even really want production on my lease when they could get it at this other lease where they're paying a smaller royalty. And so the Alexanders' complaint here is that they wish that Amico would apply for an exception well to drill another well a little bit closer to the boundary that would ensure that they get that last bit of oil out before the water rises and their entire lease waters out. So that's the basic claim that the Alexanders are bringing here. Now, why might Amico not want to drill this second well? After all, they're in the business of oil production. They only make money if they're producing oil. So why might they not want to apply for this exception well? Well, there could be a lot of reasons. One reason is that maybe it's not profitable to drill another well. They might say, look, given everything that I'm going to have to spend to drill this separate well, even if it gets me a little bit more oil, it's not worth it. Also, they might think, well, if I apply for an exception well, it's not even clear that I'll get it. But also there's that third reason, and that's really what the Alexanders are complaining about here, is we suspect that the real reason they don't want to drill another well is that they would just rather produce it from the other lease. All right, so how does the court analyze this? It says this is a field-wide rather than a local drainage case. And what it means by that is, in some ways, this would be an easier case if Amico actually owned the neighboring leases. In that case, we might say, oh yeah, definitely Amico is not being appropriate by not drilling this other well, because probably they just think we'll just produce it on the neighboring lease without having to spend the money for another well, and so maybe they're not being sufficiently considerate to the Alexanders' interest in more production on its own lease. But this is a little bit different case, because it is a field-wide case. Amico doesn't own the neighboring lease. That's owned by another company. Amico only owns another lease on the same field, not the neighboring lease, which here in this diagram is owned by Exxon. So that's the claim here. So the court says that makes it a little bit difficult. It's hard to tell if Amoco is acting from these good purposes, i.e. it's just not going to be profitable, or it would never get an exception from the Texas Railroad Commission. But the court says Amoco at least had a duty to apply for exceptions if that other well would have been profitable. And we'll see that it can be a little bit difficult to define when another well would have been profitable so that the company can be required to apply for an exception. But the court says it can't just say, look, we're following the normal conservation rules about where wells are to be located, and so we're not going to apply for any exceptions to drill closer to the lease lines. The court, however, rejects the punitive damages award in this case because it says, look, effectively, this is kind of like a contract dispute, a reasonable dispute. This is not really like a tortious action that would require punitive damages. Okay, so this is the implied covenant to protect against drainage, and basically what it's protecting the lessor from is it's protecting that lessor, that landowner, from the oil and gas company not taking sufficient action to produce oil and gas from the lessor's lease before it is drained off to neighboring properties. And as we'll see when we looked at implied covenants, this can be one of the most powerful implied covenants for getting damages. Well, if you want to make a claim under the implied covenant to protect against drainage, what do you need to show? Okay, so the lessee, the oil and gas company, has to act as a reasonably prudent operator to protect the lease premises against drainage, to protect the lease premises from having the oil drained off to neighboring properties. Now, what does that mean in practice? There's not a requirement to just drill every conceivable well, even if from the landowner's perspective that would be ideal because the landowner just wants as much production as possible. No, the lessor, if the lessor wants to make a claim under the covenant to protect against drainage, is going to have to show that there was substantial drainage from the property and that a prudent operator would have protected. Well, what does it mean to say a prudent operator would have protected it? Typically, that's going to mean that there has to be some profit from drilling that additional well. So it's not enough to show that, hey, if they drilled 4 more wells, even if they've been massively unprofitable and lost lots of money on them, they would have lessened drainage to neighboring tracts. You're going to have to show some level of profit. Now, we'll see that can be a complication showing how much profit is required. There's also complications that arise in cases like Amoco versus Alexander, where there's a common lessee. The same oil and gas company has leases that are close on the same reservoir, or as that decision also mentioned, if they're actually neighboring leases. That can be a big problem. And that's in those cases, the courts are particularly skeptical that the oil and gas company may be just trying to make excuses not to drill additional wells. There's another case mentioned in the notes after Amoco versus Alexander from the Eastern District of Illinois, where the court says, when the oil and gas company has 2 neighboring leases and the oil and gas company arguably isn't doing enough to drill on one of those leases, the court says the mind is haunted by the idea that that oil is actually just going to the same oil and gas company's well on the neighbor's land. And so those common lessee cases sometimes make the courts more skeptical of the oil and gas company, more willing to do something like switch the burden of proof. Now, the other complication that I mentioned is, it's not that the oil and gas company has to drill every conceivable well, right? It's only wells that a prudent company would have drilled. And what would a prudent company have done? Well, we've seen that in other contexts. Think about in the context of Clifton versus Kuntz, in the question of whether this is still a well that's producing in paying quantities. We said, well, it is prudent if it's something that you would have done not just for speculation, but for profit. And so the question here is, what would a prudent oil and gas company have done to protect its lease premises against drainage? So obviously it's having to consider the value to the landowner of producing more on the single property, but it doesn't have to, just keep drilling wells even if there's no profit from them. Now that can raise an interesting question, because what counts as a reasonable profit? We know that often oil and gas companies aren't willing to drill wells unless they promise a substantial profit. And so what amount of profit is required? Also, and this is another question that arises in Amoco versus Alexander. What about the conservation laws? I mean, Amoco versus Alexander just said, look, I don't need to apply for an exception well. I'm abiding by the normal conservation laws. So clearly, oil and gas companies have to follow the conservation laws. But according to Amoco versus Alexander, they sometimes have to apply for exceptions. So the question is, how much do they have to push for exceptions to the normal conservation laws to show that they're a prudent operator that's protecting the premises against drainage? Okay. Now, last thing that the lessor landowner would need to show under this covenant is damages. What is the measure of drainage damages? And so we can think about it, in a couple ways. One is how much oil was drained off the property. Another way we could think about it is if Amoco, in that Amoco versus Alexander, had timely drilled an exception well, an offset well, how much oil would that have produced? Because maybe it wouldn't have stopped all the drainage. Maybe some of the drainage would have happened anyway. So would you rather have the measure of damages that says the full amount that was drained off, or should the measure of damages be how much Amoco oil it would have produced if Amoco had drilled a timely well? You might also think that maybe damages should be different in the situation where we have the same oil company drilling on neighboring properties. Perhaps that's the kind of situation where it would be more appropriate to have punitive damages if you could show that it was really an egregious case of trying to maximize production on one property that would drain production from the other property.